I'm Catherine Pruitt, founder of Pruitt Law Group. Today, I'd like to explain the role discovery plays in positioning your case for success and how to approach your responses. First, the purpose of discovery is to avoid trial by ambush, or, as I like to say, avoid unpleasant surprises in court. When we send discovery to the party on the other side of your case, it's our chance to find out the claims they're going to make against you and to find out what evidence and witnesses they may use to prove their claims. The reverse is also true. When you are served with discovery requests, the other side wants to know what we are going to claim and what witnesses and documents we have. Even if we don't end up in trial, discovery is very important to make sure that we discover all of the assets of the estate. Two of the most common types of discovery requests in family law cases are interrogatories and requests for production. You will have 30 days from the date you're served with the requests to provide your responses to the other side. It's very important to provide our office with your information and documents at least 10 days prior to the due date to allow us time to process the information and documents and prepare your formal responses and get them served to the other side on time. To answer the question, what are interrogatories? Interrogatories are written short answer questions. You will type out written responses to the interrogatories. For example, one very common interrogatory in a child custody case asks you to explain why you claim you should establish the child's primary residence. It's very important in your response to set out any concerns you have about the other parent's parenting, such as drug use, family violence, or child neglect. If you forget to disclose an important reason supporting your claim, you may be prohibited from talking about that reason when we get to trial. Requests for production are aptly named. They're simply requests for production of or inspection of documents or things. In addition to documents relating to the financial assets in your estate, many of which you will have already produced in your initial disclosures. In most cases, you'll be asked to provide documents that relate to the interpersonal relationships that are at issue in your family law case, whether that be with your spouse, your children, or a boyfriend or girlfriend. Some examples of commonly requested documents include requests for text messages with your spouse or with a boyfriend or girlfriend, copies of dating profiles, photographs of you and the children, or you with a boyfriend or girlfriend, or receipts or records concerning travel or other documents that could be used for or against you in court. Like with interrogatories, it's important to be very thorough in producing the documents requested, because if a document is requested and you don't produce it, but you later want to use that document at trial, you may be prohibited from introducing that document into evidence to support your case. In closing, when you're faced with answering discovery, it can seem like an overwhelming task. Please don't be overwhelmed. We're here to help. We recommend taking a deep breath and taking some time to sort through the requests. Gather the information and documents for the requests that are easy for you. If there are requests that make you uncomfortable in any way, call our office and schedule a time to go over those specific requests to see if we can make a valid objection on your behalf. We'll try to make the process as painless as possible. We can't promise it'll be fun, but for most divorce cases of any complexity, discovery is just an essential part of the process. Thank you again for choosing Pruitt Law Group, and we look forward to guiding you through this process to position your case for success.